The Supreme Court A.S. sudden 6-3 ruling has triggered a profound shift in how government authority is exercised in the United States, and its consequences are already moving far beyond the courtroom. This was not a slow, predictable decision shaped by months of public debate. It arrived abruptly through emergency action, and it immediately altered the legal balance that has governed federal power for years. What makes this ruling so consequential is not only its outcome, but the message it sends about who truly controls national policy. At its core, the ruling confronts a question that has quietly reshaped American governance over the last 2 decades. When disputes arise over federal law, who has the final word on how that law operates in practice? Is it Congress, which writes statutes? Is it the executive branch, which enforces them? Or is it individual judges who interpret the law but increasingly issue sweeping orders affecting the entire country? The Supreme Court has now delivered a clear answer, and it marks a decisive reassertion of constitutional boundaries. The case reached the court under emergency conditions, a signal that the justices believed the existing legal situation posed immediate and serious consequences. Emergency rulings are rare and controversial because they bypass the traditional lengthy process of full briefing and oral argument. When the court uses this tool, it is effectively saying that waiting would allow harm to continue. In this instance, the majority concluded that the harm was structural, not merely political. For years, federal courts have expanded the use of nationwide injunctions, orders issued by a single judge, that block the enforcement of a law across all 50 states. Supporters have argued these injunctions are essential to prevent unconstitutional actions from taking effect. Critics have warned that they concentrate enormous power in the hands of unelected judges and encourage strategic form shopping, where litigants search for sympathetic courts to achieve national outcomes. The 6-justice majority agreed with the critics. The ruling emphasizes that courts exist to resolve specific disputes between parties, not to function as substitute policymakers. According to the majority, when judges issue universal orders affecting millions of people who are not before the court, they exceed their constitutional role. This, the court argued, undermines democratic accountability by shifting power away from elected branches and toward individual members of the judiciary. This decision does more than curb a procedural practice. It reflects a broader philosophy about how constitutional protections should operate. The majority opinion suggests that the Constitution's separation of powers is itself a safeguard of liberty. When authority is properly divided, abuses are less likely to persist. When power is consolidated, even in the name of protection, the system becomes unstable. The dissenting justices offered a sharply different perspective. They warned that limiting judicial reach could leave unlawful government actions in place for extended periods, harming individuals who lack the resources to bring their own lawsuits. From their view, nationwide injunctions have served as essential tools for protecting civil rights and preventing widespread harm. They framed the ruling as a retreat from the judiciary's role as a guardian against executive overreach. The majority rejected that framing. In their view, allowing courts to exercise unchecked national authority creates a different form of danger. If judges can halt laws nationwide based on limited records and narrow disputes, the court argued, the balance envisioned by the Constitution collapses. Rights become dependent on judicial preference rather than democratic process. Timing makes this ruling especially impactful. It arrives amid intense political polarization and legislative gridlock, when courts have increasingly been asked to resolve policy questions that lawmakers have avoided. Immigration enforcement, environmental regulation, healthcare mandates, election procedures, and executive authority have all been shaped by judicial intervention. This decision directly challenges that trend. The immediate effects are already unfolding. Federal agencies are reviewing enforcement actions that were previously blocked by broad court orders. State governments are reassessing how aggressively they can implement policies once constrained by nationwide injunctions. Legal advocacy groups are reworking strategies that relied on obtaining rapid nationwide relief. Even corporations are paying attention, because regulatory obligations may now vary more significantly by region. For ordinary Americans, and the implications may not be obvious at first glance, but they are substantial. This ruling affects how quickly laws take effect, how uniformly they are applied, and how disputes between citizens and the government unfold. It influences whether legal challenges result in immediate national consequences or proceed incrementally through multiple courts. Over time, this shapes daily realities, from workplace regulations to healthcare access to voting rules. Perhaps the most significant aspect of this 6-3 decision is what it reveals about the Supreme Court's current approach. The court is not merely interpreting statutes. It is actively enforcing constitutional structure. By limiting the reach of lower courts, the justices are signaling that no branch, including the judiciary, is exempt from constitutional limits. This ruling does not close the book on these issues. Instead, it opens a new chapter filled with unanswered questions. How will lower courts adapt their practices? Will Congress step in to clarify laws rather than leaving disputes to judges? How will executive agencies navigate enforcement amid geographic variation? These questions now define the legal landscape. One thing is already clear. This decision marks a turning point. Government authority in America is being recalibrated not through sweeping legislation, but through a firm reassertion of constitutional boundaries. The effects will not be temporary, and the debate over what happens next is only beginning. Now that the Supreme Court has reset the boundaries of government authority, the real consequences are beginning to surface, and they will shape how power is exercised long after the headlines fade. Court rulings do not simply resolve disputes. They change incentives, rewrite strategies, and force institutions to adapt. This 6-3 decision is already doing all three at once. The most immediate effect will be fragmentation. Without sweeping nationwide injunctions, federal policies may now operate differently depending on location. A regulation blocked in one judicial district may move forward in another. Supporters see this as a return to constitutional normalcy, where courts address individual cases rather than managing national policy. Critics fear it creates a legal patchwork where rights and obligations depend on geography rather than citizenship. Federal agencies are now recalculating risk. For years, a single unfavorable ruling could shut down an entire enforcement program nationwide. That reality encouraged caution and delay. Now, agencies may proceed more aggressively, knowing that adverse rulings might only apply to specific plaintiffs. This could accelerate policy implementation, but it could also increase uncertainty for individuals and businesses trying to understand their legal exposure. State governments are also adjusting. States that previously relied on nationwide injunctions to block federal policies they opposed may find those tools weakened. Conversely, states defending controversial laws may see new opportunities to enforce them beyond narrow jurisdictions. This shifts power back toward political actors and away from the judiciary, forcing debates back into legislatures and elections. For advocacy organizations, the ruling represents a strategic reset. Litigation has long been an efficient way to achieve national change quickly. That approach may now require multiple lawsuits in multiple courts, raising costs and slowing momentum. Smaller organizations could struggle while well-funded groups adapt. This raises concerns about access to justice, even as it reinforces constitutional limits. Ordinary Americans may feel the impact indirectly at first. Over time, however, differences in enforcement will touch daily life. Workplace rules, environmental standards, healthcare access, immigration enforcement, and election procedures could vary more sharply between regions. The same federal law may feel strict in one place and dormant in another. This reality forces citizens to pay closer attention to local courts and regional legal developments. The ruling also sends a message to Congress. For decades, lawmakers have increasingly delegated responsibility to agencies and relied on courts to resolve conflicts. By narrowing judicial power, the Supreme Court is implicitly telling Congress to legislate more clearly and assert its authority. Whether Congress responds remains uncertain, but the pressure is now unmistakable. Politically, the decision reshapes accountability. When courts can no longer provide instant nationwide relief, voters may focus more on elections as the primary means of change. That was a central argument of the majority. Rights and policies, they argue, should be shaped through democratic processes rather than judicial shortcuts. Critics counter that this ideal ignores real-world barriers faced by marginalized groups. Looking ahead, lower courts will play a crucial role. Judges must now define the limits of their authority carefully, knowing the Supreme Court is watching. Some will adapt cautiously, others may test boundaries. This period of adjustment will likely produce conflicting rulings and renewed legal battles, eventually sending more cases back to the Supreme Court. The larger story is about trust in constitutional structure. The court is betting that limiting judicial power ultimately strengthens democracy by restoring balance among branches. Whether that bet succeeds depends on how responsibly Congress and the executive act in the absence of broad judicial restraints. This ruling does not end legal conflict. It redistributes it. Power is moving away from single judges and back into a system that demands negotiation, legislation, and elections. The process is slower, messier, and more political, but it is also closer to what the Constitution envisioned. As the legal landscape shifts, one reality is clear. Government authority in America is no longer operating under the same assumptions. The rules have changed, and everyone, from agencies to citizens, is now navigating a new era.